If you've ever wondered what takes place behind those courtroom doors after someone passes away, or if you think probate only affects the wealthy, then this video is for you. Today, I'm pulling back the curtain on probate court, what it is, how it works, and why understanding it could save your family time, money, and stress. I'm John Farrell, estate planning attorney at the Farrell Law Firm, and I've seen what happens when families are caught off guard. Let's make sure that's not you. So imagine this. Your loved one passes away. You're grieving, but suddenly you're also dealing with court papers, deadlines, legal fees, and hearings with the judge. That's probate court. But here's the thing. That's just scratching the surface. What really happens next might surprise you. Probate court is the legal process that takes place after someone dies. Its job is to make sure a person's debts are paid and their assets go to the right people. Sounds simple, right? But that's not the whole story. Even with a will, your estate may still have to go through probate. The court validates the will, appoints an executor, oversees the distribution of assets, and ensures everything is handled properly. And if there's no will, here's where it gets tricky. The court uses default laws, not your wishes, to divide things up. That can create conflict, confusion, and a lot of resentment. Let's break down what really happens at probate court step by step. First, a petition is filed to open the probate. Notices go out to heirs and creditors. The will is validated, or the court figures out who the heirs are. An executor is appointed to handle the estate. All the assets are located and inventoried. Debts and taxes are paid first, and finally, the remaining assets are distributed. Seems straightforward. However, you can't really complete the process without court supervision at nearly every step. And that's where delays, costs, and mistakes often creep in. Now here's where the real issues begin. Probate court isn't just a checklist, it's a legal marathon. First, the costs. Court fees, attorney's fees, and executor fees can drain up to 4 to 7% of the estate's value. Second, the time. 6 months to 2 years is common, and even longer if someone contests the will. And third, it's public. Anyone can look up who inherited what, how much it was worth, and more. You might think, that's just how it works. But no, there are ways to avoid all of this, and we're going to get into them. So far, we've covered what probate court is and why it can be a real burden on your loved ones. But understanding the process is only half the solution. To truly protect your family, you'll want to take the next step. And hey, if this kind of clear, no-fluff legal guidance is helpful, hit that subscribe button. We break down estate planning topics every week so you can make smarter decisions and avoid costly mistakes. Trust me, your future self will thank you. Here's how you can keep your loved ones out of probate court, and it starts with planning ahead. Number 1, a revocable living trust avoids probate completely. Number 2, beneficiary designations on retirement accounts and life insurance bypass the court. And number 3, joint ownership and transfer on death designations can streamline transfers. But, and this is important, you can't just set up one of these tools and assume you're protected. They have to be coordinated. Your trust needs to be funded. Your accounts need up-to-date beneficiaries. Otherwise, your plan could still end up in probate despite your best intentions. The truth is, most people only learn about probate when it's too late. But now you know what it takes place, what to expect, and how to avoid the most common pitfalls. If this opened your eyes, give it a thumbs up, share it with someone who needs to hear this, and subscribe for more practical estate planning advice. And if you want personalized help to make sure your estate stays out of court, there's a link below to schedule your free consultation. Thanks for watching, and I'll see you in the next video.